quote, right to control its assets by depriving of information necessary to make economic decisions like hiring. As in Girton, the government is trying to turn a 1001 case into a wire fraud case.
The government argues that there's a difference between obtaining and maintaining employment, and that Girton was about the latter. Why isn't this different because he got the job in the first instance?
Well, the court in Girton obviously bypassed the opportunity to make that distinction and instead went on a broader basis, the basis we're talking about. And, you know, the government had argued in Girton that there was no difference between maintaining and obtaining. And the court did not go on that basis. I guess I don't see a difference. If the lie gets you your money, your salary, but really the question is, did they get the benefit of their bargain? Not, you know, whether it was before or after you were employed. Either way, TIGTA is only being deprived of honesty as such in this case, just as in Girton.
But that's a kind of a shallow reading in some ways, because you're just basically saying that as long as I'm doing my job, no one is complaining, I'm getting the satisfactory performance, and then the employer is paying me, that's all I need. But it sounds like under Girton, you could take it to a different level. Now, we didn't agree with the Ninth Circuit, so I do agree with you there. But we're talking about the high integrity of the position, and that pre-employment concealment, fraud in the application, but then even while they're on day one, you need a trustworthy investigator, because immediately the credibility of the office is shot if one of that investigator's files is at issue in a trial, et cetera, what have you, despite the high level of performance.
Well, a couple of answers to that. One, that's equally true when you already have the job, and you're lying. You've got the same problem. But I would also say more fundamentally, the benefit of the bargain has to be impaired, not by the fact that you lied, which is what the government's arguing here, that you are a liar and therefore you lack credibility, but by the information you kept from them. That's what normally happens in a wire fraud case. You tell them something that's not true, and if they'd known that fact, and here that fact is the NCIS investigation, but the NCIS investigation was over when he was working. So that fact never impaired
what are you admitting to earlier? You know, with respect to falsifications, you said we admit certain things. So what are you admitting to? Because the government is considering all of that.
I'm sorry, I'm not understanding.
Earlier in your opening presentation, you said you admit or concede to certain facts with respect to, I guess, the pre-employment answers. So what are you admitting to? Because right now I hear you saying he didn't say anything that necessarily impacted his pre-employment answers or application for why they actually hired him.
Well, I mean, we acknowledge that the government was trying to make the case that he had misrepresented the circumstances under which he resigned.
And so you're not admitting anything with respect to pre-employment or with the circumstances as to how he resigned and how he answered those questions?
Yeah, I'm sorry, I'm not totally understanding.
I guess I'm asking you, what is he admitting to? What is he conceding to with respect to his answers or alleged falsifications?
I don't think we're conceding anything, if I'm understanding.
Okay.
I mean, we're just saying that assuming they're correct, I guess, assuming they're correct, that there were false disclosures, those disclosures are what has to go to the heart of the bargain. And the government is saying it's the lying that went to the heart of the bargain because we can't hire a liar.
Mm-hmm.
And that would be true in every wire fraud case. You could criminalize, you could turn any disclosure into wire fraud because wire fraud by definition requires a false statement. So in any law enforcement hiring case, any 1001 violation, and even probably some things that might not rise to that level because of materiality even could be wire fraud. And they're just trying to turn 1001 cases into wire fraud cases in the court in Girton specifically.
They argue this. I mean, I know in their briefs here, they talk about the exceptional need for honesty and candor in law enforcement. Did they argue that theory to the jury?
No. Well,
When I went,
They just pointed out the only evidence that they're now trying to grasp onto, which was not put in for the purpose they're now using it for. They did point out that he had to go on administrative leave because he can't be, I guess they used it to say, number one, that you can't work in law enforcement while you're under investigation. Of course, he didn't do that here.
Mhm.
So that's all they put in. And they put it in for just the purpose of showing that he wouldn't have gotten the job.
Mhm.
But that's not the question here. The question here is, did they get the benefit of the bargain? Did the information that allegedly wasn't disclosed,
Mhm.
affect the benefit of the bargain? Or are they really complaining that they were deprived of honesty?
Mhm.
And we would say it's clear that it's the latter. And just as in Girton, the indictment charged that the purpose of the wire fraud scheme was to obtain paid employment. Just as in Girton, Mr. Barrow allegedly lied about his, quote, suitability for that employment. So Girton can't be meaningfully distinguished. I think anything we can say about this factual situation is as the same or worse in Girton. And actually, so the government had the burden of proving that they didn't receive the benefit of the bargain. And the bargain was the exchange of money for work. And
That's why I thought it was curious that I know it wasn't at the trial itself, but at the restitution stage, they only had a very, very small amount of money, $2,400 or something, that was allocated to having to reinvestigate some matter, even though he'd been employed for, I guess, close to a year, 10 months, something like that. So it seems like this claim about that he can't do the work, he couldn't do the work,
correct.
wasn't at least shown up in the restitution stage because it was only a tiny amount that they had to
That's right.
redo.
And I'm glad you brought that up because assuming we could even look at that, which we don't
Mhm.
think you can because that's outside the record. That goes to what I was
What's in the
just,
record of the case? You mean outside the jury record? The record before the jury?
I'm sorry.
You mean outside the record before the
Yeah,
jury?
outside the sufficiency of the evidence. Yeah,
Okay.
but yes, that's what I mean. Sorry. But because that 2,500 is exactly my point. They didn't rework his cases because he used to be, before he arrived, under a cloud of a NCIS investigation.
Because he
That's
wasn't
not,
under investigation when he did his work. Is that
he was not under
when
investigation.
he
when
actually
did
started his job? Or the timing when he started?
timing, I think the investigation was dismissed like August
August.
30th, and he started work October 1st.
Okay.
And so, but
So he didn't do any work while he was under investigation?
no. And they reworked the case because he was under investigation then for these offenses. Now he is under investigation, but that's for this offense. You can't bootstrap,
Okay.
every wire
Oh,
fraud.
I understand. Okay.
Yeah,
So that
okay,
was-
But he was specifically asked, did you ever quit? Or being asked or forced to resign, words to that effect, during this process. And that's part of the fabrication that's at issue.
That is the allegation that he answered those yes or no questions incorrectly. But what we're saying is, even if he didn't do that to deprive them of property. He always intended to, and in fact did, give them full value.
And I think there's a distinction on that and the government's argument, a very fine line argument that having a dishonest employee on your payroll does not give them the benefit of the bargain because immediately that trustworthiness that should attach to the officer and that could harm them later in any type of investigation or trial when you put the person up. Mark Furman in the OJ trial.
Well, I'm sorry, I lost my train of thought there. I have lost my train of thought. What you're saying is that, I guess what I would say is in Girton, that was equally true and that they needed his integrity. He has to have a security clearance. If anything, that's a higher standard of integrity than what's at issue here. So I don't see how that distinguishes Girton in any way. And this is not the kind of information, the fact that that at one time he was under a cloud, but that cloud was disappeared. That would not be something the government would ever have to disclose to anyone in a case, in a trial, that the fact that he had this former problem and is now working on a case, when that case comes, that's not information that's going to harm the government in any way. It was only once they realized that he had arguably lied to them, that they're like, we have to investigate this and you're under investigation. So now, you're no use to us. So we're going to have you do administrative duties and then we're going to put you on investigative leave. So we would say that's what happened here.
I mean,
How do we,
you go ahead.
just what's the error that we should look at? How are we to our standard of review here?
Well, it's sufficiency of the evidence. And we're saying that because the government didn't realize that what it was supposed to be proving, it thought all it had to show was that he got a job by depriving Tigda of information, but neither the job nor the information is property within the meaning of the wire fraud statute under Girton and under Simonelli. So they didn't put in what they needed to put in for a reasonable jury, rational person to find beyond a reasonable doubt that he intended to deprive of money or property, and because they didn't put in evidence that suggests they didn't get that his lies went to the heart of the bargain, which was his ability to do the job. So that's.
But the DC Circuit also suggests that it could be plain error review because at the stage of acquittal, there was kind of the generic, request for acquittal based on all the charges. But then once you got specific, you tipped yourself over into plain error.
Yeah, well, we disagree with that. As we say in our reply brief, there was a broad motion of the type that this court has held. You can make the most general motion in the world, just the words everyone always says, we move for judgment of acquittal on all counts. That preserves everything. The fact that he then went on to say something additional doesn't waive the preservation that he's just engaged in. And that's particularly true here where the judge sort of suggested that the court expected some argument. And you can, these arguments that were made, it's pretty apparent that they were just, scrambled together to say something. There was like zero merit to those. And counsel never went back to ever try to supplement, never accepted the invitation to do that because it appears that the counsel didn't really intend to make specific arguments and was just trying to check the boxes for the court of what it wanted to hear. And so it would be particularly unfair to then now treat those sort of box checking statements as somehow waiving the general motion. And I'd say the cases where this court has found that a specific motion waives waives anything else, you can't tell in those cases that I saw whether there was a general and then specific, or if it was very clear that I'm only arguing this. And we would say it was not clear here that that the argument was limited to it. Why would counsel do that? That would be a crazy thing to do. So I don't think we should read the record to suggest that counsel would just undermine his own motion for judgment of acquittal like that.
On this honesty or special need for honesty theory, I'm trying to figure out how that works because even half-truths can trigger fraud charges, right? That counts as deception, a half-truth. And so is the theory that, and I know it's hard because they didn't try the case on this theory, but is the theory that you have to have special honesty in officers mean that sort of any half-truth or puffery on a resume is suddenly going to become a federal case?
I mean, I think
fraud?
It seems like under their theory, any
Even if they
mistake,
got the benefit of the bargain.
certainly in a law enforcement case, they would be claiming that any mistake, anything on your resume that's not 100% right is a false statement or is half true, then your credibility is in trouble. And because of they've tried to bootstrap this honesty thing in, and that's not what the Girton court was thinking when they were talking about what it is that has to impair the bargain. If the court has no questions on that, I'm moving on to the intent errors. The government has conceded that it was error to exclude that Mr. Barrow told the interview panel that he had left Army CID. And the government tries to show that that was harmless, but it can't meet its burden. It argued that the government argues that he wasn't charged with concealing that he had left. But its theory was that he had intentionally misstated his employment status as a critical foundation for the scheme, and that it was one of the 5 lies that worked together to create the plan. The government says that the disclosure to the interview panel would have been cumulative of other disclosures of the same information, but the timing is important here, because the excluded disclosure, so his initial application had conflicting information about his employment status in May. The excluded disclosure happened shortly thereafter in mid-June, where at the in-person interview with the 3 TIGTA agents sitting across from him who were going to decide whether to give him the job, he told them that he was unemployed. So,
Let me stop you, Ms.
yes.
You have a bunch of evidentiary issues, and unless my colleagues have questions about specific,
Sure.
we do know what your argument is.
Okay.
Well, I had one question at least. So if you're right on the wire fraud convictions,
Mhm.
which evidentiary objections remain? So it would have to be addressed.
All of them. I don't think there's anything that's unique to the
Do you think
wire.
it also went to the 1001 charge, all of?
Yes, because I think the intent to defraud, conceal, and the intent to defraud, I mean, it's the same intent and it's being impaired equally as to both, because both involve false statements and both involve you have to intend it. And one thing I did forget to say on the wire fraud is that if the court were to think that somehow the government accidentally proved, had enough evidence sufficient to prove that the benefit of the bargain had been impaired, we would still get a new trial on wire fraud because our job performance evidence was excluded. So no matter what, we would need a new trial on the wire fraud. And then of course, we also have all our new trial arguments that go to all the counts. But I'm happy to take whatever
You're not
questions.
challenging the count 3, concealment of a material fact, right?
Well, we're asking for a new trial on that count because of all the
Right.
procedural errors.
Right.
But we're not saying it's insufficient. We're
And
not saying it's insufficient.
Do you know offhand what he faces for that count?
Alone.
Uh-huh.
I'm not sure what the guidelines would be. Whether it would be, the same or less, I don't know. But
Hasn't he already completed? his
yes,
sentence?
but we're not, the issue here is really just getting him to acquittal because,
He's already served his full sentence.
yes, he has. Well, except for the not supervised
I'm sorry,
release.
the incarceration sentence.
Yes. So I haven't focused on how the guidelines would change. Is that it?
Let me. Okay, we'll give you a couple of minutes and reply.
Thank you.
Okay, Mr. Cahill.
May it please the court, Timothy Cahill for the United States. The evidence was sufficient to support the wire fraud conviction because a rational juror could have found that Barrow's fraud deprived TIGTA of the benefit of its employment bargain when it hired him to be a criminal investigator. Unlike honest services fraud, TIGTA was not merely deprived of honesty as such. There is evidence in the record in that trial that Barrow's fraud directly undermined the value of his services as a criminal investigator, a job that included duties such as gathering evidence to be admissible at trial.
Where was that in the job application that was posted? The need for a special honesty?
The job application, I don't think specifically said the need for.
Didn't say a word about it. Who during the
Oh.
interview asked him a question? When did this come up during the interview about the exceptional need for honesty?
So, Your Honor, I can point to, I don't think there was testimony about the interview. I would point to Shanda Jones' testimony, the TIGTA's personal security specialist who evaluated his application, who specifically did testify that it was necessary to have a higher standard of integrity. And there was other testimony as to why that was, about the danger of criminal investigators' cases getting thrown out in court if their integrity was subject to attack, about the fact that criminal investigators needed to do things like gather evidence that would be admissible at trial, needed to do things like testify at trials if their cases went to criminal
This
prosecution.
just isn't the theory on which the case was tried. It's
So
not
I would-
the evidence, it's not the theory on which it was tried, was that you didn't get the benefit of the bargain. The government kept objecting every time defense tried to put in evidence to show that you got the services you asked for. And the Supreme Court was quite clear in Simonelli that we cannot, after the fact, pick out little pieces of evidence here and there one witness's one statement in a different context and try to cobble it together to come up with a whole new theory of the fraud and substitute ourselves for the jury and convict somebody.
So, Sharon, I
I
think
didn't even
that,
see this in your brief. You argued plain error, that it wasn't plain error. But I didn't see that a whole argument section that lays out for me the wealth of evidence showing that this was put before the jury, that it was argued to the jury by the government. And if it was argued, how could the court possibly have precluded the defense from putting in its evidence that in fact you did get the benefit of the bargain?
so I think that question encompasses a few issues. Your Honor, I'll try to address all of them. First of all, while we do argue that plain error applies here, I want to emphasize that we don't view that as determinative. We indicated in our brief that even under the highly differential sufficiency review that traditionally applies to sufficiency review, the government should prevail here. I just want to quickly address Your Honor's reference to Simonelli. That wasn't a sufficiency case. That was a case where there was a jury instruction that specifically instructed the jury that they could convict based on intangible rights. This jury was properly instructed that it could only convict on deprivation of money or property. There's no jury instruction claim on that element. This is only being reviewed for sufficiency, what a rational juror could find. In terms of the evidence in the record, Your Honor, I would submit that we did outline it in the brief. I would point to testimony on the appendix A 1880 to 81, A 1931 to 32, A 2384 to 85. All of those are testimony about.
Pages, okay.
So, Your Honor, I get so.
I just didn't, when I look at your opening argument, your closing argument, all the arguments as to why the benefit of the bargain evidence that they wanted to put in was irrelevant in the district court's words. And the government was objecting that it was irrelevant because it didn't matter in the government's words and the court's words if they got the benefit of the bargain. It was about whether he lied to obtain a salary, whether he lied in the government's words to get, his job back, to have a gun back, to be an investigator again. That's what was said and again. So I'm not sure how these three little pieces aren't exactly what Simonelli said we can't do. We can't piece it together afterwards on a different theory.
So again, Your Honor, so I want to try to respond again to all of the pieces there for Your Honor. One is that I would acknowledge this was not the emphasis of the government's argument. This was not a case this was a case tried after Gurdon, before Gurdon, not after Gurdon. That said, this is sufficiency review. The question is whether the evidence was sufficient, viewed in the light most favorable to the government, granting all reasonable inferences. And the evidence that was there was sufficient that a jury could credit.
You acknowledge that the government objected when the defense tried to put in evidence about benefit of the bargain, that it was irrelevant?
So, Your Honor, and I do want to address the take to work performance reviews as well. And so the government's objection there was that didn't go to an issue that was in dispute. And we maintained that. The issue was the government's theory, even now as we're arguing, that the deprivation of the benefit of the bargain was a criminal investigator whose integrity could be attacked, not a criminal investigator who lacked the ability to perform the individual tasks of completing an investigation.
There's nothing that granular in the case. The government said and the court said it's irrelevant whether you got the benefit of the bargain.
I think they said it was irrelevant whether he did the tasks performing the job well, because that wasn't an issue did the actual tasks.
Did them well. If he didn't
well, yes, Your Honor.
If he didn't do them in a way, it wouldn't, I assume the government's position would be that if you investigated something well, but your character was so impugned, you couldn't be trusted and your evidence you gathered wasn't worth anything, that he didn't do the job well.
I think this is actually a very good point, Your Honor, and I want to follow up on it, because I think what Your Honor is striking at actually helps draw a distinction between an honest services fraud case and this case. In an honest services fraud case, the only harm is that the employer has employed someone who is a dishonest employee, someone who they can't trust, who might not be performing the services with loyalty and with honesty. And this court and other courts have held that if that's the only deprivation, then that can't sustain the deprivation for wire fraud. But here, so I'm so sorry, Your Honor, if I could just.
Please, no.
Because I guess I'm trying to finish the thought as to what Your Honor's question was. I do want to answer Your Honor's concern here, which is that here the harm wasn't that the prospective harm wasn't that he wouldn't be doing the investigations well. There was no dispute there was no argument that he wasn't doing the investigations well. It's that those investigations wouldn't have had the value to TIGTA as a law enforcement agency that they bargained for, that any evidence that was gathered would be impaired from being used in a criminal prosecution. that if Mr. Barrow needed to testify in a criminal prosecution on a case that he investigated, he would be impaired from being able to do so because his integrity could be so subject to attack. And that's the bargain they were paying him for.
So one correction, Simonelli was a sufficiency of evidence case. And that's where the Supreme Court refused to allow courts to pick and choose your 3-sided pages of transcript evidence, and then the nuances about performing well and performing in a way that's going to hold together in court. And given, again, that the defense tried again and again and again to put in evidence about the ability to perform, about his performance of the job, his ability to perform the job, get the benefit of the bargain, and his intent, which is really what we're talking about here. Did he intend not to give you the benefit of the bargain? I don't understand how we could pick these few pieces of evidence and accept that it was somehow undisputed when we don't have the defense evidence in. I'm assuming when your friend gets up on rebuttal, she'll say there was a lot of dispute about all of these things.
Well, no, I don't think there's, frankly, Your Honor, any dispute, again, about the fact that he had experience performing the tasks of doing investigations. And that's all that his work performances would have shown. At worst, the exclusion of the work performances was harmless error. Because the government, and I do want to go back to another question Your Honor posed, which is whether this was...
Is it true that the government never redid any of his work in this case, because even after it found out he'd been under investigation at the time, at least of...
I believe at sentencing there was evidence that there was one investigation that was done. And
Yeah, so defense counsel just, that's like the $2,400, but defense counsel said that was work that he had done that was at the time they discovered the lie and started their own investigation. Is what record evidence was there before the jury, which is really the only thing that matters right now. What record evidence was there before the jury that he intended, or you can do it either from the intent side or that you actually lost the property, that in fact the government did not receive the performance that it needed and that it had to throw out his work, redo his work?
So there's a few things there, Your Honor. One, I just want to do quickly correct that the work that was redone was done because it could not be relied upon to be used in a criminal prosecution. I believe that was...
No, I'm not disputing that. The question is which investigation was the problem there? And defense counsel said the investigation that was the problem there was TIGTA's investigation, not the CID investigation.
So, Your Honor, I don't think it's in the record which what it is, but the fact was that it had to be redone because he had committed the fraud in this case. But to circle back,
they said it was redone because he was under investigation by TIGTA, so they had not yet actually made a conclusion.
That I think is actually not correct, Your Honor. And I actually did not, and I don't mean to say Haaland's counsel misrepresent that. I don't think that actually, at least in my recollection, is how it was framed. It wasn't because he was under investigation by TIGTA. Once he was under investigation by TIGTA, he was placed on administrative duties. He wasn't doing investigations at that point. It was based on his earlier fraudulent representations. I think my Haaland's counsel's argument would point,
he wasn't under investigation at the time he did any work.
Well, he was an individual. He had done the work after he had committed fraudulent misrepresentations to get employment, which made him somebody who TIGTA would not want to sponsor his work as a government, as a witness.
So the argument here isn't that you had to redo it because of the CID investigation. It's that if you had to redo it because he made a fraudulent misrepresentation on his application form, you would have had to redo 100% of his work. Not this teeny tiny little percentage.
So this also ties in with one of your other honors questions, because I think that's actually not also correct. Because the point is that the work would need to be redone if it was going to be used in a criminal prosecution. Not every investigation leads to a criminal prosecution. Mr. Barrow was only there for...
Is there any evidence about all this in the record that you're telling me?
Sorry, Your Honor?
What is the evidence in the record about why this particular,
There's very little, Your Honor, and that's why I don't mean to delve into it. I'm trying my best to respond to Your Honor's questions about it. But I also want to take a step back and point out that for a wire fraud conviction, there actually isn't required to prove actual loss. What's required is a scheme to defraud. So the fraud was committed at the moment that he made...
Wait, you have to have an intent.
Yes.
To defraud of property.
And
if you want to say the property is law enforcement investigator who didn't shade anything on his job application. You have to show that it was his intent. And yet the fact that you just said 99% of what he did, the government got the benefit of because you said there's only this tiny amount that maybe pertained to a court case, but everything else you didn't have to redo. And that, in fact, is what the district court found at the restitution stage, that you got the benefit of the bargain for all the months he worked. The only thing the district court gave you, and you haven't cross-appealed, is the time when he was on non-work leave.
So, Your Honor, first of all, there's no minimal amount of damage here that needs to be proved. In fact, there doesn't need to be any actual loss at all. The district court here found actual loss, and at least the actual loss that Your Honor is referring to, the investigation that had to be redone, that actual loss isn't in dispute. But that isn't an element of the wire fraud. Well, wire fraud was committed when if the fraud had been discovered on day one when he showed up, this still would have been the same case. He still would have committed the same crime. So in terms of, I did also want to address something before it gets, lost in the shuffle that Your Honor had questioned earlier about whether the government had made any arguments along these lines at trial. And I'll point, this is on A2841 to 42, where during closing the government argued why the fraud mattered to TIGTA and said TIGTA is a law enforcement agency just like Army CID that cannot take risks that its criminal investigators outside issues would put its agency work in jeopardy. It didn't use the phrase benefit of the bargain, but I would submit that that means exactly the same thing. That's why TIGTA did not get the employee that they hired, the employee that they agreed to pay his salary to, because they didn't get an employee.
But now you're arguing that we had a loss, which you said doesn't matter. What I'm trying to show is where is the evidence that he intended to deprive you of that, as opposed to he had whatever his views were about, the explanation at CID, which.
Well, yes, Your Honor. So, I mean, I would submit that there was extensive evidence about that.
He intended to give you an investigator whose work wouldn't hold up. That's your argument here. You had a right, the property you lost was it was an investigator whose work would hold up with reliability levels needed for a law enforcement.
So given that Mr. Barrow had worked as a criminal investigator, that knew that an investigator who committed significant criminal offenses or was under investigation for offenses or committed fraud, that work would be put into question. In fact, that actually happened at CID long before he ever applied to TIGTA. At CID, he was placed on administrative duties because he had to be able to be taken away from all of his case files. They couldn't risk the danger that anything he worked on those case files could be jeopardized. So certainly he had the knowledge that that would happen if he was hired at TIGTA for the same job with these major integrity concerns. So there was, and the jury necessarily found that he had the intent to defraud, that he had the intent to conceal these things.
Where is all this argument about how there is sufficient evidence on this particular theory in your brief? Because the only sufficiency argument you have is didn't do plain error. And then you argued about the obtain, maintain distinction. So if you can tell me where in your brief you laid out how there was sufficient evidence and how the government actually indicted and proved his intent to do this. Not that there's a little piece of evidence here and there, because that's what was exactly the argument in Simonelli, and it's exactly what the Supreme Court rejected.
So, Your Honor, I would note that we indicate on page 20, note 14, that we believe that either standard of review for a sufficiency claim is sufficient for the government to.
Okay, that one sentence. Barrow's claim would also fail under the highly deferential standard of review for preserved sufficiency claims. That's it?
And Your Honor, except for the one argument that we make with respect to whether the court could consider evidence outside of the trial record, which is it's a relatively small part of the sufficiency argument, the rest of the sufficiency arguments are the same. I mean, the standard of review might affect what the court's doing with it, but the arguments as to why it was sufficient are the same.
Wait, I'm utterly confused. It's not in your brief. You've made a lot of, and I appreciate it, and I appreciate your careful knowledge and review of the record and your efforts to answer my questions. I 100% appreciate that. But this is not the argument that's in the brief. This is not you told me you have a one-sentence footnote, but of course, that's not enough to preserve an argument in this court.
Your Honor, frankly, respectfully, the one-sentence footnote was about the standard of review, saying that we prevail under either standard of review. My point is that the substantive arguments are the same under either standard of review. I would point to pages 23 and 24, where we say, Gerton does not support Barrow's plain error sufficiency claim. There was evidence at trial that Barrow's fraud deprived TIGTA of the benefit of the bargain when it hired him as a criminal investigator, which is, I think, exactly the argument Your Honor is
That's one-
referencing.
that's
And what
one-
follows, I understand Your Honor
Mhm.
may not agree with our position on that evidence, but it certainly is in the brief.
I'm sorry. What I'm trying to get to is that that's what the case was about. That the bargain you were deprived of was this higher standard of integrity that didn't show up anywhere in the application process that I could see. You can correct me if I'm wrong. And that that someone described that they have to collect evidence and sometimes swear at warrant affidavits, testify oath in court. But there's just really no evidence that you lost anything that was before the jury, that you didn't get from him. Now, maybe it was because it was only 10 months or something, less than a year that he was there, but there's no evidence before the jury that I saw, because these things were in a very different context. And to be fair to you guys, it was pretty great. I mean, to be fair to you, it was pretty great. You were doing it under a different state of law, but it just wasn't the theory of this case.
And Your Honor, I want to emphasize that on sufficiency review, what we're looking at is whether a rational juror could have found that this was satisfied. And again, we submit that a rational juror, from viewing all of the evidence in the light most favorable to the government, drawing reasonable inferences from this testimony, from this evidence about the higher standard of integrity that is necessary and the consequences when it's not satisfied, that TIGTA did not receive the benefit of
Why
this bargain.
Why did the government keep objecting when the defense tried to put in the other side of the story?
And so, again, Your Honor, I would push back on the other side of the story because the defense wasn't trying to admit evidence that would push back on the theory that a criminal investigator with integrity concerns was of less value to TIGTA. That wasn't what the work performance reviews would have shown at all. Those work performance reviews were completed before the fraud was ever discovered.
That was their theory of why the government, you can disagree and argue to the jury, but that was their theory and their evidence of why he didn't intend to deny the government of the work it was looking for. And the government didn't lose anything. And I understand you say it wouldn't have persuaded the jury because of your arguments, but that's not how trials work. The difficulty with this case is, and the reason I think the district court kept saying this is irrelevant, because the government had pre-Guertin, understandably, a different theory of what the property injury was. And the argument was that he lied in order to get the property of a salary, that he ordered to get the property of a position. That's really, that's at least how I have read this case.
So I want to address at least
99% of what was about. Maybe there were a couple little references here, but they were all to the end of, see, he wouldn't have gotten, had he told us the truth, he wouldn't have gotten the salary. He wouldn't have gotten the job, the gun, the badge. He wouldn't have gotten those if he had told us, because we can't have people under investigation working for us, or that had to be the argument, because it can't be, if he hadn't lied to us, if he had told us, then he wouldn't have lied to you. You wouldn't have had that. The whole argument has to be, had he told us he was under investigation, which he wasn't when he started working. And so that's how the evidence came in.
And so Your Honor, I want to address at least two things encompassed there. One is, to the extent, again, the government objections to the TIGTA work performances and the trial court's ruling that they didn't go to an issue and dispute, even if the court finds that was an erroneous ruling, we would submit that on this record that was harmless error. There was no, because that wasn't an argument the government ever made, was that he was incapable of the tasks of performing an investigation. The other thing I do want to address, though, Your Honor.
Sorry. I just want to make sure I understand that. What you just said again? Say that again?
So
it wasn't relevant because it wasn't what you were arguing? Or
it was in terms of the sufficiency of the evidence on being deprived of the benefit of the bargain, even now on appeal, Your Honor, we're not arguing that they were deprived of the benefit of the bargain because the actual tasks day-to-day, moment-to-moment of performing an investigation, that he wasn't capable of doing that. It was that the work that he did was of less value to them because it couldn't be used in a criminal prosecution if any one of his investigations ended up having to go to a criminal prosecution, which he was fired, I mean, he ended up being fired 10 months or being removed from his criminal investigative duties 10 months in. Investigations can take a long time. If they were hiring an investigator, though, part of the bargain was to get somebody whose work could be used in prosecutions.
That means that the property he took was the salary.
Absolutely, Your Honor. And I want to emphasize.
Burton says it's not enough.
I strongly disagree, Your Honor. Neither Girton nor any court has ever held that salary can't be the property. In fact, Girton contemplates scenarios where the salary can be the property. What Girton says is that the salary can be the property, but the government needs to show that there was a deprivation of the salary, so that if they got entirely their benefit of the bargain, then the salary wasn't deprived. But if they didn't get the benefit of the bargain, if they got something less than the benefit of the bargain, then the salary was deprived. I'd point on page 451 for Girton. It says when employees' deceits don't deprive the employer of money or property, but it says then unless there's a showing that the employer would have paid less for a dishonest employee's work. So here we have evidence that they wouldn't have paid anything for.
You have to, it's insufficient if you allege that there was a State Department was deprived of something more than Guertin's honesty. And that's exactly the deprivation here, was honesty, not while he was working, unlike Guertin, but honesty in the job application. That's what you were deprived of. Yes, you were deprived of honesty in the job application.
They were deprived of a lot more than that, Your Honor. They were deprived of a criminal investigator whose work could be used in criminal prosecutions, which is an essential qualification to have someone conducting criminal investigations, is that the work they do could be used if there's a prosecution based on that investigation. And they were deprived of that.
Okay, where is the evidence that all his work was thrown out because it couldn't be used?
That isn't the standard, Your Honor.
I'm just, okay, you.
It doesn't exist, but that doesn't resolve the question.
Okay.
The
So
question is whether or
I'm
not they were
gonna ask it
deprived
two
of
ways.
the employee that they paid to hire, and they were.
Mhm. But if the, first again, this benefit of the bargain goes to intent, yes? And property.
I think I would say first and foremost, the benefit of the bargain goes to the question of the deprivation of
property.
money or property.
Right.
Now, there is also a requirement that there's an intent to deprive of money or property, but I would say first and
Of
foremost,
that.
it applies to the element of deprivation of money or
It's not a
property,
first and
the
foremost.
scheme.
It's not first and foremost, it's, we have to define the property that's being deprived in terms of benefit of the bargain, just as a shorthand from Guertin.
I would frame it a little bit differently, Your Honor, because the property is still the tangible property interest of the salary. The question of whether that salary was deprived is contingent on whether or not there was the benefit of the bargain wasn't satisfied. If you paid the money, you were deprived of the money. If you didn't get back in return what you paid the money for, then you were deprived of at least some of that money. You were deprived of the value of what you were paying for. And we submit that a rational juror could have
I thought
found
we
on the
were
evidence
saying
here
the
that that's
same.
what was.
I thought we were saying the same thing.
But perhaps we were in different
maybe
wording,
not.
Your Honor.
And then, but you still also have to show that he had the intent. He had the intent to, when he fudged on his forms, lied on his forms.
And again, Your Honor, we would submit that the evidence.
When he lied on his forms, he had the, sorry.
I apologize. I thought you were done. I
My brain is
apologize.
going a lot slower
Nope.
than yours this morning, so.
I apologize. I will wait.
No, it's my slow brain. So he had the intent to deprive you, not of the position, not of the salary, not of the badge, not of the position, but he had the intent to deny you a reliable investigator. That was the goal. That was the intent of his lying, was to deny you an investigator whose evidence and work you could use.
So
Correct?
Your Honor,
Is
I don't
that-
think he had to, I'm sorry. Again, I
I
thought
just
Your
want
Honor
to make
was.
sure, so, I don't know if you're about to talk about record or anything. Am I right in saying that's what the intent needs to be?
I don't think that's quite right. I think the intent has to be to have deprived them of the money or property. So if he sought a salaried position for which they were going to pay him, knowing full well that he was not going to be the caliber of employee because of his integrity issues that they thought they were hiring, then that satisfies the intent requirement. His end goal doesn't
Doesn't
need.
have to intend to, because you want to put the benefit of the bargain and deprive, not property, I think is what you said before.
The benefit of the bargain is an analysis of whether there was any deprivation.
Deprivation.
Because the whole idea in Girton, and so there's,
It can't be whether there was deprivation, because you don't have to, you've told me many times, we don't have to show that. So it has to be whether he intended to deprive you of that what shall we call it? The useful investigator.
yes, you're right, but I guess this goes to, that doesn't, his ultimate goal doesn't need to be somebody sitting around twirling his mustache saying, I'm gonna really mess up Tigda's work. That doesn't need to have been his overarching goal. But if his goal was, under false pretenses, to get a job, lying to Tigda about the caliber of employee he would be, about the qualifications he had, by hiding his integrity issues that was going to ultimately undermine that work. He was knowingly and intentionally
You're just
depriving them of the
arguing
benefit of their
inferences
bargain.
the jury could make to find intent. Are you saying that the intent requirements, Ray, it doesn't apply to deprivation as
No,
well as property?
not at all, Your Honor.
So if it applies to deprivation of this particular form of property, okay, you're shaking your head.
No, I'm sorry. I'm trying to
it.
clear my head, Your Honor. I apologize. I'm trying to
Maybe
follow.
on my end, but if it is an intent required finding for this offense, and the intent has to be the fraud, which is the deprivation of some property beyond just a salary post-Burton, okay? And beyond just a position post-Burton.
And again, Your
I don't
Honor.
know how you can say what you lost, your whole theory now is that there was this super special investigator thing that we were deprived of. And it can't be that you can make that argument without having to show that he intended to deprive you of that thing, if that thing is the linchpin to having a viable fraud claim post-Burton. It just can't be. If that's your linchpin for a viable fraud claim post-Burton, you have to show he intended to do that.
And so I would just point again, Your Honor, to if that were true, then some parts of the Girton decision would frankly make no sense. The fact that Girton contemplates the fact that there could be a showing that an employer would have paid less for a dishonest employee's work, that it would have valued it less, wouldn't be a viable fraud claim. But Girton suggests that it is. Girton just says in Girton that the government didn't make that showing. The government's position in Girton was it didn't have to make that showing. So it didn't attempt to make that showing. But Girton never says that that showing wouldn't be sufficient for wire fraud. In fact, it indicates that if that showing is made, that it would be sufficient for wire fraud. I see that I'm well over time. If there are any further questions.
Judge Childs has
Yeah,
a question.
well, just more of a limiting principle, because earlier we started out, just kind of talking about if you had fraud essentially in the application. This case is brought about because you later learn about it, and so that's why you have differences on the restitution charts. But what about on any instance that an employee has fraud in the application? Are you telling me that immediately there's a criminal charge against that employee? And I think that's kind of where we're going about that. You could find out 20 years later, none of the investigations were affected. And then all of a sudden you want somebody to charge this particular employee with a riot fraud crime, even though none of the investigations have been challenged. But you find somehow that there was something wrong on the resume or something wrong in any part of the application process. So I'm just trying to think.
So if Your Honor's imagining the exact same scenario, but it's not discovered until after everything is closed, I would actually submit that that doesn't affect the evaluation of whether the crime was committed, because again, the actual loss doesn't need to be proven. So given that the intent and the deceit and the misrepresentations all happen at the moment of the application, at that point, he is seeking to be hired for a job, knowing full well that the integrity challenges that could be raised against him could jeopardize any work that he did for TIGTA. Now, if by some series of events, it doesn't end up happening, that actually doesn't, might affect a restitution evaluation, but it wouldn't affect whether the crime of wire fraud was committed.
So you say on day one, anybody in any of these agencies who has got some falsification is eligible to be.
Well, Your Honor, all of the other elements still have to be met. It has to be shown that it was a material misrepresentation. It has to be shown that they were deprived of the benefit of who they thought they were hiring, depending on the job that may or may not
And
be
despite that,
applied.
we just talked about your words that you could close out all these files, nothing happened during that time.
So I think the distinction I'm drawing, Your Honor, and that I thought Your Honor was driving at, is the distinction between whether or not his integrity concerns were hiring somebody whose deficiencies could impair, and I would suggest very likely would impair criminal investigations, or Your Honor's hypothesizing some scenario where it's so far in the future that we know that as a factual matter, they did not end up impairing a particular or any particular investigation. And with that, I don't think that distinction actually would affect whether the individual committed the crime. Because again, if this had been discovered the day before he went to TIGTA, he still would have committed the crime.
Okay, and then you agree that this higher standard of integrity that you're talking about is really intangible?
No, Your Honor, I wouldn't. Not as a requirement. In fact, I would
When I
say
say intangible, an intangible type of alleged property, as opposed to money or property that we're, specifically speaking about here.
so if the only deprivation is honesty or is integrity, I would agree that the concepts, I guess, writ large of honesty and integrity are intangible concepts. But again, the deprivation of property here was the deprivation of the salary for having hired somebody you had, and it wasn't just intangible problems with integrity that somebody might not trust him. It was, I mean, he had something that someone could bring up in a court criminal proceeding to have his work thrown out.
Okay.
That's the tangible effect.
Okay, and then you, as the government, you'll have your theory of the case. And let's say your theory of the case is everything that we've been discussing here, this high standard of integrity that could somehow affect investigations later. Then a judge will actually instruct the jury about the benefit of the bargain. And then the jury then looks at all the evidence that you've had in the case and determines whether or not you've met that definition beyond a reasonable doubt. So back to Judge Millett's questions, essentially on the benefit of the bargain piece, how is this not a jury issue factually? In other words, that's your theory, but the jury, after the judge instructs, has to feel that the evidence was actually sufficient in the record to meet that definition. And right now we're talking about under your wire fraud indictment that it says devised and intended to devise the scheme of fraud and to obtain money and property. That's what you're going off of in your theory.
And again, so first and foremost, Your Honor, I would say is because there's no jury instructional claim raised here. It's not before the court with respect to this element. I understand there are other jury instructional claims. So the claim here is raised only in the context of sufficiency of the evidence. There's no challenge that the judge's instructions with respect to this element were deficient or that they affected the verdict. So, I mean, I think in this case, it's simply not before the court, the question of how the jury was instructed on this element. Again, I understand there are
Well,
other
and I guess
instructions.
what I'm going to is that I'm not challenging that the jury was instructed wrongly, but that you have a theory, the judge instructs the jury, and then the jury makes this determination. When I was referring to Judge Millett, I'm sorry, I didn't finish my thought. The defense does not get the opportunity to bring forward its side of the theory of your case when you don't allow the issues with respect to the defendant's performance so that they could challenge how the jury was instructed to the extent of that's your theory of what benefit of the bargain means, but they have a different theory of what benefit of the bargain means. And then present all of that in front of the jury and the jury chooses.
I understand, Your Honor. And so I would want to say again that viewing the admission of that evidence, I assume Your Honor is referring to the work performance evidence that was attempted to get in, viewing that evidence in that light, if this court decides that the exclusion of it was error, I would reiterate that our view is that that would be harmless error. I believe there's no danger here that the jury convicted Mr. Barrow on the theory that he was not capable of performing the tasks of being an investigator. All of the evidence showed that the duties of actual investigative work between his job at CID and at TIGTA were the same. And so if anything, this evidence would have been redundant of that. I understand Your Honors and Judge Millett's points that maybe the defense would have found it beneficial to have argued that it was, to have more affirmatively argued it rather than it simply being an issue not dispute. But to the extent that that was error, we would submit it was harmless error for the reasons I've outlined here.
All right, thank you.
Thank you, Your Honor.
Does Ms. Wright have any time? All right, why don't you take 2 minutes?
Thank you. First, I think the government's attempt to pass this as a plain error claim suggests that the government recognizes that Girton is indistinguishable. I'm hearing the government concede that Mr. Barrow did do the job properly. They are saying that his work had no value because they couldn't use it, but they could use it. It wasn't until he was under investigation, and once it wasn't under investigation for so we've discussed earlier. It was only once it was discovered that they suddenly could use it, and that would be true in every case, no matter how small the misrepresentation or the little omission on the resume. That would always be true. The government suggests that there's some doubt as to why his work became problematic, and that it's not. And I would point to in the sentencing exhibits. That was said 3 times by TIGTA. They explained in their memoranda putting him on administrative leave. They said that the reason he was going on administrative leave was allegations of false statements, and that's 936. On 934, when they put him on investigative leave, they said potential false statements are calling into question the employee's character. And when they suspended him, 932, they said allegations of false and misleading statements in the application for employment go to credibility. So it's very clear that's why there's a problem. That's why they have to put him on leave. It's not because he used to be under investigation by NCIS. And to be clear, just to sum up, we can prevail under any standard of review. If there's insufficient evidence, that is a miscarriage of justice. I want to also be clear that all our arguments are reasons for a new trial. Obviously, we rely on our briefs as to all of those. And I think I failed to state that everything goes to the concealment count and the wire fraud count, but we also do have one argument, the duty to disclose instruction that goes just to the concealment. And that would require, if we're correct about that, that would require a new trial on that. And then
Do you have a response to their argument that it was undisputed, that he knew he wasn't giving them, and because of his experience as a CID investigator, that he knew if he got the job, he wouldn't be able to give them the benefit of their bargain, that is an investigator whose work they could use?
I think if you're asking about, they seem to be saying that they didn't dispute it, or so they're
Undisputed in the case, which would mean you didn't dispute it either, and that is that your client, I say knew, although the test is intent, but knew that if he got the job, he would not be providing the government the investigator they were looking for, because he knew he had lied on his forms, and so he knew he wouldn't, his integrity wouldn't be able to stand up in court.
I mean, obviously, we disagree with the whole premise that he's lying. We also disagree with any suggestion that he thought the investigation was going to be ongoing, even if he knows there's this investigation.
I think they're arguing the second point about lying on the employment forms.
About
lying on the employment form. I mean, it gets confusing which one they're arguing about, but are they lying about the lying on the employment forms about the prior investigation? So sort of hooking the two together.
Yeah. I mean, I'm really not understanding, honestly, what the argument is.
Is there any dispute that your client knew if he got the job, he wouldn't be giving TIGTA what it was looking for? That is a reliable investigator whose work could be submitted to courts.
Not at all. And because he's not thinking he's going to be working for them while under this cloud. He thinks the investigation is going to be over. I mean, it's unclear that he ever knew the investigation was still pending until, August perhaps. So I don't know. At the time, he's not at all intending to work there under a cloud, not at all. I was just gonna, and you know, what they say about that they've conceded that he could do the job and therefore the exclusion of the performance evidence was harmless. I mean, they may have conceded that in their mind, but the jury certainly wasn't told that. That whole argument was ruled off base and out of bounds. So finally, I would just say that, you know, we're relying on everything in our brief, which, you know, the government tries to pick apart in their brief all the ways that Mr. Barrow was prevented from defending himself and sort of justify and say they're all that not important. But the case was close and all the errors compounded on each other, such that you can't really read this record as a whole and come away with the conclusion that this trial was fair on any of the counts. And so we asked for dismissal of the wire fraud count and a new trial on the concealment count, and alternatively a new trial on all counts. And in any event, reversal of the $74,000 of restitution.
Thank you.
Thank you.
Case number 23-1294. In re Encep Nurjaman, petitioner. Mr. Thirschwell for the petitioner, Ms. Daring for the respondent.
Proceed. We might use my cane.
Take your time.
Apologies for the interruption. Your Honors, the in the Military Commissions Act of 2006, Congress very clearly and unequivocally barred the use of torture or the admission of torture in military commissions. And it's very clear that what they meant was all of military commissions, the whole process. The issue in this case, of course, is that the lower courts held that the 948R does not apply to the referral stage or the charging stage. And the petitioner, the government at the time earlier, took the same position as the CMCR, but by the time it got to this court, and I think maybe even in the CMCR, the government agreed with us. So we have a situation in which the parties are in agreement about the meaning of a statutory provision, and the court is not, or the lower court is not. And since they are not implementing Congress's clear intention, it falls to this court to do so via the petition for mandamus or other extraordinary writ.
Why isn't what we held in Al-Nashiri number 4, that a similar admission of evidence derived from torture claim can be dealt with on direct appeal after the end of a commission proceeding? So there's an adequate alternative avenue for relief for closing mandamus. Why doesn't that apply in this case just as much? You have that same alternative adequate avenue for obtaining relief.
It is, in our case, there is, of course, the possibility of direct appeal after a final judgment, but the nature of the violation is affecting the entire course of the proceedings.
That's something that can be raised. I mean, that's sort of saying it was harmful error that pervaded the proceeding, but that's still something that can be raised at the end of the trial or at the end of the commission proceeding and review process. And so it's all for mandamus. It's just such an extraordinary and rarely used power. And the number one factor you have to show is that you don't have an adequate alternative avenue for raising these claims. And you just said, of course, we can raise it at the end of the proceeding. So I'm just, given what we said in al-Nashiri 4, I'm not sure why that's not, doesn't make clear that Davis is foreclosed here.
I didn't quite get a chance to finish my
I'm
statement.
sorry.
It can be raised on appeal as an issue, but it is because of the nature of the torture program and the effect it had on the defendants, all of the accused in military commissions, the other detainees who gave statements to the FBI after similar abuse, and the evidence that was gleaned from that, there is a tangle of what will, through the poisonous tree issues that would have to be, will have to be untangled in any case that in which torture is involved. And I want to emphasize that when I say torture, I mean the CIA's rendition, detention, and interrogation program. This is not about an individual officer choosing to beat a suspect with a rubber hose until they confess. Those cases are wildly different from this one. The RDI program was unique in its severely damaged defendants and clients, making them difficult to actually cooperate with their lawyers or even accept their lawyers for a very, very long time. It's unique in how much evidence was derived from other detainee statements. These were individuals were largely charged with a widespread conspiracy that culminated in the 9/11 attacks. All of the detainees had charges that implicated that, and the government. So these are people who are talking about each other. They're talking to each other, and it's so that is unique. It's unique in its scope. It's unique in the deliberate use of violence, and mostly it's unique in the systematic approval provided by the highest levels of the executive branch. I mean, this was a policy that involved multiple agencies, and I don't need to go into it. I mean, you're familiar with the RDI program, but the point is, it is completely unprecedented. So, and part of that is, again, the issues that I'll talk about under the harmless error rubric also, because it's those same issues mean that it can be, if it does, let me put it this way, if it does wait for the final judgment and appeal, the defendant, Mr. Nurjaman, has to have the opportunity to dig up the background of all the evidence that he's got. And I mean, that's a thing that defense lawyers do. But in every case, but this one again it's complicated. In his case, many of the witnesses against him live in Yemen, and were provided by the Yemeni police to the FBI to give their statements. There are enormous, obstacles to making the analysis that would be required to separate out any torture taint from the untainted information. So when the requirement for the issue of
the torture he was subjected to, I'm not asking about the details of it, but this whole RDI system different in al-Nashiri?
similar. They were, I mean, al-Nashiri, well, I can go on, but al-Nashiri was one of the very first individuals who were put in the RDI program, and he may have gotten the worst treatment, but they were everyone in the RDI program. Mr. Nurjaman's name is listed in the back of the SSCI executive, as one of the people, executive summary of the torture report. His name is listed there. He was subjected to the same routine and approved, in many cases, mostly by the Office of Legal Counsel. So he was tortured. And that's one of the,
Guess what so the government itself agrees. No one here is trying to say what happened was okay, acceptable, or, really even tolerable, at least in an evidentiary sense. The question I'm just struggling with is we're bound by prior panel decisions. We are sitting as an en-banc court today, and al-Nashiri was subject to the same RDI process that you're raising here, and no doubt would have had the same claims of pervasive corruption of evidence that you are presenting here. And yet we said the time to raise that is at the end of the whole proceeding and not before. Is there a basis for distinguishing this case from that one?
I understand the question, and there is, but it's because of the effect of the RDI program on all of the evidentiary basis for the prosecutions of these cases. I mean, it's not, there is evidence that was not tainted or not, possibly tainted by torture, but a great deal of it is derived from statements by detainees made to either the CIA agents or the FBI after they were transferred to Guantanamo.
This was a 1,300-page binder in which we're talking about, was it like 9 or so pages that were at issue? So did you all actually see everything that was in this binder?
I did
I'm just
see
trying
it.
to get a
I
sense
flipped
of
through it.
the-
I'm not prepared to talk about individual
No.
items.
But my point is that, do you have any evidence of the fact finders actually utilizing that information? Because here they're saying it's very sufficient otherwise, like even taking that out, there's enough evidence there. But I was just curious if you have any evidence of the fact finder actually utilizing that.
Well, I mean, we do not. We're not privy to the convening authorities'
Right.
decision
But there's
making.
nothing in any writing or ruling to suggest that it had to have come from those pages.
That is true, but I would cite Fulminante, which had a discussion of the very, very extraordinarily large effect on a jury or other decider like the convening authority of confessions by the individual who's being charged.
Well, in al-Nashiri, the government withdrew the pages. Do you have any idea about why not here?
I think the government will make the argument it makes, but I think its argument is essentially that we got that process of examining the rest of the evidence and finding it sufficient without the torture statements is the equivalent of that Nashiri remedy. It's the problem. The problem is that Nashiri dealt with like individual decisions relating to mostly a discovery and the scope of discovery. But I mean, this is the original charge. So this renders the whole process as a process, ultra virus. I mean, it should not stand if it was based on a statement of torture. And the government can argue that there's sufficient evidence. I mean, otherwise, and there may well be. I think there clearly is. I did read the statements that the CMCR cited that showed that he had, but like that just raised more questions for me. I mean, and for a petitioner. I mean, we need to unless we can dig under there and find, trace who was tortured, who they talked to, and when. But with your indulgence, I'd like to just move on to get some of the other mandamus requirements covered. And I'd say that the petitioner's right to relief is indisputable. I mean, I don't think that the government will contest that. Congress was well aware of the Convention Against Torture when it enacted Section 948R. It had, when it amended the section in the 2009 Act in a fairly significant way, what it did was expand the prohibition, not constrained it. I mean, it could have weakened it. It could have created exceptions. There are no statutory exceptions. The CMCR simply reads one of the terms, admissible, as meaning admissible at trial only. And that, of course, is one of the technical meanings that admissibility can have, but it is perfectly consistent with all the other meanings that it has in other contexts. And like it could be evidence that's used at trial. The Convention Against Torture says, evidence that's invoked at trial. I mean, all of those things are the equivalent of the admissibility that the Congress was talking about in that section. I mean, and I don't want to beat this to death, but it's hard to understand what the justification would be in terms of the purpose, the legitimate purpose for finding that only applied to trial.
But you're not asking to have the whole prosecution thrown out, though. I thought you said in your petition that you just want them to go back and consider the referral process without any torture-based evidence.
Well, we do want to vacate the underlying charge sheet. So,
But you didn't say that they have to, but they can, you didn't dispute that that this would make the case go away, that they could do, you're not contending that they couldn't then.
the case will go away. The case will go away. I mean, if
Can they do another referral based on non-torture based evidence, in your opinion?
Yes.
Okay, that's what I'm trying to say.
Yeah, no, that is our position. I mean,
Okay, but then it's not so pervasive that they couldn't do this. It's just
well,
that there's
they
this
could
case-
try. They could try. These same issues would arise, but the pure issue of the use of statements directly out of a tortured accused's mouth would be gone. That's the big problem. The other evidentiary problems that torture creates, are there, and they're in every case. And Mr. Nurjaman will undoubtedly pursue them if it is in fact dismissed and they refer him. But it's the use of the personal statement. I want to address one issue that has come up in terms of the clear and indisputable right to the relief. The standard is generally you have to point to a case that says this is a violation. It is, and of course we do not have that. And this court has said that it had, the quote is never required the existence of a prior opinion addressing the precise factual circumstances or statutory provision at issue in order to find clear error justifying mandamus relief. That's United States v. Fokker Services 818 F3rd 733 2016 case. So it's clear. I mean, Fokker, explains why the uniqueness of this case is not an impediment to your finding that the writ is warranted in this case.
But indisputable means there's no debate. Right.
Well, that's true, but
But you
I
made a
should have said
representation earlier that you believe the government would agree with you, and I don't think they did.
Oh yeah. I mean, that maybe not. I mean, I don't know. I mean, I think what they would find indisputable. Well, they'll speak for themselves. I think they will concur that the statements should not have been entered into the referral binder, and they should not have been considered in connection with the charges. I mean, the rest they can argue. It's so, and similarly, other adequate means of relief. Talked about that a little bit, and it's clearly that one thing that stands out. It's very appropriate under the circumstances. If for no reason that a decision affirming the lower court's opinion or failing to overrule it amounts to a legal green light to the government at a minimum to torture individuals to seek a basis for charging them. And that I say at a minimum because it's not, the holding of the CMCR is not clear. They say in one place, all admissible in all pretrial proceedings, and they say in another, maybe it means only referral. So I'm talking about referral here, but excuse me. But the point is, this case is not comparable, and the fact that it's not comparable actually in these unique circumstances is not something that should militate against mandamus. Appropriate under the circumstances, the Fokker Services case, addresses the appropriateness of the entry of a mandamus there, the Fokker is a significant case because it closely resembles this one. I mean, it was a case in which the parties in a criminal case came to an agreement, under the Speedy Trial Act, and it was, a deferred prosecution agreement, DPA. So the government agreed to postpone charges while the defendant had the chance to rectify the wrongdoing itself. And this was a company, a corporate defendant. Everyone agreed, we'll do that. And the section, there is a specific section 31.6, I think it's 3161 H2 of the Speedy Trial Act that speaks directly to the DPAs and their legitimacy. It includes the language, statutory language.
Mr. Thurswell, you're over your time.
I am.
We'll give you a couple of minutes in reply.
Okay, thanks very much. I urge you to read Fokker. Thank you very much.
May it please the court. Petitioner cannot establish an entitlement to writ of mandamus dismissing his military commission case because he has an adequate alternative remedy. Petitioner acknowledges that he can raise his claim on direct appeal from final judgment that the military judge erred in denying his motion to dismiss for a defective referral on the ground that the convening authority considered materials in the referral binder that he or she shouldn't have. But petitioner contends that this alternative remedy is inadequate because the taint of torture has irreparably contaminated the proceedings. But that isn't true because, as the military commission demonstrated, it's possible for this court on direct appeal from final judgment after the CMCR reviews the claim to determine whether the military judge erred in denying this motion to dismiss for a defective referral by simply just excluding the excerpt from the 9/11 Commission report that petitioner challenges here, reviewing the remaining materials in the referral binder, and then assessing whether the military judge erred in making that probable cause determination.
Can I ask a quick clarification on what there's talk about sort of government concessions here? My understanding is that the concession was the use of torture-derived evidence in pretrial proceedings. Is that right?
The government has
Or
not taken.
trial, okay.
The government has not taken a position on whether Section 948R would apply to the referral process. As the military commission explained below,
I'm just trying to ask what the government has thus far said.
Okay.
And I thought
And
that
all
the
the yeah.
limitation was pretrial proceedings?
No, in
Oh.
Al-Nashiri 4, the government's position was that it will not seek to admit at any stage of the military commission proceedings statements obtained by torture under Section 948R. But as to the referral process,
Oh, just talking about then, and that at any stage, I thought there was one where the government said that includes pretrial proceedings.
pretrial proceedings, yes, but not a referral because the referral occurs before a military commission is ever created.
So how do we, so I'm just trying to understand how we know what is pretrial. Because the charges and specification and service of charges are under the pretrial procedure subchapter
Well, it's,
of the statute.
the military judge said that the referral process isn't part of a pretrial military commission proceeding because it occurs before a military commission is even created. So the purpose of the referral is to determine, for the convening authority to determine whether to create a military commission. Military commissions, like courts martial, aren't standing courts. They're ad hoc courts, so they don't exist until a convening authority creates one.
I understand, but something can still be, I'm just trying to understand where the government's definition of pretrial comes from, because it doesn't seem to map onto the statute, which for better or for worse, in 948Q, which is the charges and specifications, that's considered part of the pretrial procedures, even though that's what causes the convening of the commission. And so I'm just confused about, one can think about in our system, arrest and detention in the police station as pretrial. At least if a prosecutor has said, yeah, do that, even if it hasn't yet been referred to the court until they are actually arrested and detained. And even then you got, 48 hours. So, so how does the government concession, how do they define pretrial? And why, and that's my first question, is how do we know? So is pretrial just starts the second the commission is convened, is that right?
Right. So Section 948R provides that no statement obtained by the use of torture or cruel, inhumane, or degrading treatment shall be admissible in a military commission.
Well, I understand the statutory. I'm asking about the government's concession, which seemed to me potentially broader, because using something in some pretrial proceedings wouldn't be the same as admitting it in a military commission. So I'm really asking not about the statute, but about the government's position.
So our position in Al-Nashiri 4 related to any stage of the military commission proceedings. And the referral
Including
process.
pretrial proceedings.
Yes, Your Honor. And but here the government, and we don't think that this court has to decide whether Section 948R applies to that referral process, because you can assume without deciding that it does. And even in that event, petitioner would have this adequate alternative remedy, and the military commission has already granted him adequate relief by, after the military commission had been convened, the government provided to the defendant all the materials in the referral binder. And that's when the defendant reviewed them and objected just to this 9-page excerpt, filed a motion to dismiss for defective referral. And the military judge said, okay, I will look at these materials without the excerpt, and I've determined that the remaining materials are sufficient to establish probable cause. In our brief and at the CMCR, the court relied on this court's decision also in the Coppage case to explain how a similar procedure is used in the grand jury process. And there, the defendant at the district court and on direct appeal from final judgment argued that the court should dismiss the indictment because the grand jury considered allegedly perjured testimony, and the district court and this court rejected that claim by looking at the other materials that the grand jury considered to decide that those materials were sufficient to support the indictment. So we think that
Does the government intend to use torture-derived evidence in its referrals going forward?
No, Your Honor, the government does not intend to do so.
Don't we have to decide first whether the exclusion of, or the use of torture is a structural error? Because if it isn't, then on appeal, he's already been tried with a structural error, that is.
And we think that on mandamus review, petitioner hasn't established that it qualifies as a structural error. One, because they don't cite any authority to establish that. But two, the Supreme Court's precedents really look at whether this is the type of error that can be fixed. Is it a type of error that's subject to traditional harmless error standards of review? And we think that it is. And the Military Commission demonstrated how, is that on direct appeal from final judgment, this court would just simply exclude the excerpt.
Okay, my question is, don't we have to decide that it is not a structural error?
I think
And
that you
then-
could, I think that you could still address that question on direct appeal from final judgment. And then the petitioner would have a more favorable standard of review because it wouldn't be under mandamus. Under mandamus, he must establish a clear and indisputable right, but also that he doesn't have an adequate alternative remedy. And we think he could still raise the structural error claim on direct appeal from final judgment.
Because every structural error argument is not mandamusable pre-criminal trial.
Correct.
Mandamus is narrower than structural error.
I'm sorry, Your Honor?
Mandamus review is narrower than structural error.
Yes.
A little bit about the timeliness issue, because it was supposed to be filed within 20 days, but we also have some precedent that when you're on mandamus, it's a little more liberal. So I was just curious about why that wasn't challenged.
The timeliness, yeah, we understand that they can raise a petition for writ of mandamus without waiting for a particular time.
Okay.
The government respectfully requests that this court deny the mandamus petition. Thank you.
Thank you.
I'm going to briefly address a few of the things, a couple of the things that the government stated. I was surprised, well, to hear their answer with regard to their position on referral and saying that it's not, the use of torture is not a violation if it occurs at the referral stage. I think that is what she said. But I just want to point out that in the CMCR proceeding below, prior to this one, and I'm reading from the CMCR position, which quotes the government brief, the petitioner and respondent, and this is the quote, are united in recognition that torture of any kind is legally and morally unacceptable, and that the judicial system of the United States will not permit the taint of torture in its judicial proceedings. And what they did not say is, except it's okay for the charges. It's okay for charging. So I question, the government is trying to, okay, I won't. The other thing I wanted to say is that
the commission said here, or the courts below said is, we're throwing aside that evidence that you identified as torture derived. We're taking that out, and now we're going to make our decision.
yeah,
So that's not relying on torture derived evidence. That's refusing to rely on torture derived evidence.
But the convening, there's a procedure for military commissions, and the convening authority is the ultimate charging and referral authority.
But if the government says, whoops, you're right, we will not pay attention to that evidence, we are throwing it aside, that's, you were just charging them with being in favor of relying on this evidence. And I don't think that's what this record shows.
That's what they suggest now, but they said in the brief, the general statement is a general strong condemnation of the use of torture in any form, in any judicial proceeding in the United States. I mean, it doesn't matter, my interpretation of their language, but it's not clear what they really mean and whether they are actually
I assume if the United States government represents in this court that will not use torture derived evidence in convening papers going forward, that it will not do so.
Well, the problem with that, Judge, is that there is a ruling by a court of superior jurisdiction over the military commissions that has said torture evidence can be.
Doesn't matter if the government chooses not to it's the government that puts together the charges. They put together the supporting documents. The court wasn't saying we will force the government to use torture derived evidence. So if the government has said we're not going to use it and has said that as a matter of public record in a court of law by an officer of the court, I just don't think it's fair of you to characterize them as saying, oh, they'll be fine, go ahead and do it going forward.
Judge, this is a question of voluntary cessation, and it's the government can represent.
No one's arguing mootness here because your client.
Yes,
that's a prospective policy.
Yes, but the argument, I think, is even though the CMCR has authorized as a matter of law the use of torture pre-trial, and that is what it holds. We promise we won't act on that. So like that, and so you don't have to
We
worry about
won't use that, is what they said.
we won't use torture. That's right. They're promising that.
Torture-derived evidence.
Yes, they're
Okay.
promising not to do that. I believe that statement is made in good faith. I also know that there's going to be an election in November, and it's unclear, whether the personnel at the Department of Justice are going to change, and there will be outstanding a ruling that torture evidence may be used pre-trial. I don't think the government can guarantee anything past the date of the election. I mean, I appreciate that they will try not to use it, but that does not cure the problem. I mean, the problem is that the CMCR made this ruling against, I won't, the arguments against
Is
that.
it, then you can challenge it on appeal. That avenue will remain open to you.
That's true. But in the meantime, these proceedings have been taking multiple years. And so for multiple years, the CMCR opinion is controlling law. And so it's an unusual case because it has an effects far beyond this case. I mean, we can do a final appeal, but whenever that happens in the very indeterminate future, prior to that, the government can use information pre-trial if they change their mind and change their good faith commitment not to, which they may do when there's new personnel in the Department of Justice. I think that's a realistic possibility. I want to say one final thing about what I said about final appeal. I did say, yes, Mr. Nurjaman can appeal after final judgment. But I didn't mean that would be effective or that was a meaningful avenue for relief because of all the reasons I discussed previously. So I don't want to be backed into a position of where I conceded that, final appeal is a valid, adequate, alternative mode of relief. That is not our position. And it's not what we argued in the brief. We argued the opposite. So I just want to be clear on the record that is our position.
Thank you.
Case number 22-5302. Leatrice Tanner Brown, personal representative of the estate of George W. Curl Sr. and of the class of similarly situated individuals, and Harvest Institute Freedmen Federation LLC, on behalf of itself and all persons similarly situated, appellants, versus Debra A. Haaland, Secretary of the Interior, and Tara McLean Sweeney, Assistant Secretary, Indian Affairs. Mr. Squire for the appellants, Mr. Richmond for the appellees.
Mr. Squire, good morning.
Good morning, Your Honor. May it please the court. Counsel. Your Honor, I would like to begin by number one, thanking this panel for according the opportunity to my clients to have their cause heard by this court, given the long-standing and historic nature of the deprivation that they are seeking to remedy through this appeal. The background to this appeal, I'm sure, is well known to the court, and I don't want to waste time going over things that the court already is conversant with, but I'd like to start by saying that the basic concern that is raised by this appeal is the disparate treatment that's been accorded to my clients, who are the descendants of Cherokee freedmen, from their tribesmen who are referred to historically as Native or blood Cherokees. And that distinction is so relevant here because the district court concluded in this case that despite the request for identical relief that was raised by the Blood Cherokees in connection with their claim of breach of fiduciary duty by the Secretary has been met with the argument in this case that my clients lack standing because of their inability to point to a concrete and particularized injury capable of redress by the government, or their lack of the requisite personal stake in the outcome to confer standing and to make this justiciable. These claims have been pursued for some time by my clients, but have always been thwarted at the threshold level based upon the allegation that the dispute as presented by them is not justiciable. This derives and begins with an 1866 treaty under which relationships between the Cherokee Nation and other members of tribes referred to historically as the 5 civilized tribes were normalized following the Civil War. Following the 1866 treaty, which stated that any right of citizenship for Native Cherokees must be extended equally to freedmen, resulted following the General Allotment Act of 1887, the Dawes Act, and the 1898 Curtis Act, which allotted the land of Cherokee freedmen, took place. The ancestors of my client, George Curls, and his siblings were enrolled members of the Cherokee tribe. In 1902, when Mr. Curls was 5 years old, he became an enrolled member of the Cherokee tribe. And in 1910, after the allotment of the Cherokee freedmen lands, when Mr. Curls was 13 years old, he received a 60-acre allotment. That allotment was subject to the act, which really is the focus of this appeal, which is the act of May 27th, 1908.
Before you get to that, can I ask a question? So in your prior appeal, we held that there was a lack of standing because Ms. Tanner Brown didn't have any, or sure, at least at that time, identify any legal capacity in which she was connected with Mr. Curls' estate. And on this complaint, it alleges that she's bringing the action as the representative of the estate, correct?
That is correct, Your Honor.
How is she was there a legal document, a will, a court ruling? What does it mean that she's
There was a court
representative?
I didn't mean to interfere. I'm sorry, Your Honor. Subsequent to the initial attempt to bring the act in her own right as a descendant of George Curls, and the court concluded that if there was a cause of action at all, that it accrued to Mr. Curls himself. Ms. Tanner Brown went back to the appropriate probate court and was appointed the personal representative of the estate of her grandfather.
So she now has the legal interest.
Yes, Your
that
Honor.
we
And
said was missing in the prior appeal.
yes, Your Honor, that is correct. And the district court acknowledged that. The district court basically said, well, you're a little closer this time, but no cigar. And the reason for that is because you have not alleged a concrete particularized injury.
Mhm.
My concern with that conclusion is that the court did not focus upon the relief that Ms. Tanner Brown actually was pursuing. The court required it to be shown that in order to bring this claim, there must be some evidence of some wrongdoing or damage to the actual allotment of Mr. Curls. And that was not the claim here. The claim here is the same nature of the claim that was raised and recognized by this honorable court in the case of Eloise Cobell. And that is that the Native Americans here, the freedmen, are entitled to an accounting concerning the treatment accorded to their allotments by the government.
But even to get that accounting, what are you deriving that from in terms of either the May Act or some statutory provision? You're bringing a cause of action generally for this accounting, but under what basis that there's some duty to give it to you?
Your Honor, we're basing it on the authority of the Eloise Cobell case. This court stated in the Eloise Cobell case that the Cherokee natives were entitled to an accounting for the treatment by the government of their individual Indian money accounts. In the case of the Tanner Brown plaintiffs, there were no individual Indian money accounts because those freedmen were treated differently than the so-called blood Cherokees. What you have here is a situation in 1898, the Curtis Act allotted the lands of the 5 civilized tribes. To the extent land was allotted to blood Cherokees, the revenue and so forth derived from those allotments, despite the act of May 27, 1908, continued to obtain the protection of the United States government. So the revenue from royalties from those allotments and so forth were placed in the individual Indian money accounts. In the case of freedmen, who the treaty had said are entitled to the same status, that revenue was never put into individual Indian money accounts. These freedmen and their interests were basically ignored. When the government concluded in Cobell that the United States had a duty to provide an accounting, there was no finding that an equivalent duty was owed to the freedmen because the freedmen's position was never recognized as being equivalent. It's our position.
Your argument is that it should be.
It should have been equivalent.
That's your legal argument on the merits.
That is our legal argument on the merits to get over the standing barrier.
We have to assume you're right on the merits. That's at this stage, we assume you're right on your legal merits in analyzing your standing. Whether or not you are is to be decided later.
That is correct, Your Honor.
We have to assume you're right that either statutorily or through unfair or unequal treatment, you were entitled to an accounting just like the other Cherokee members. Assuming that, then you have asked for an accounting, and that's your injury as a deprivation of accounting. Do I understand
Is the injury,
right?
that is correct, Your Honor. The injury is the deprivation of the accounting, which could not be justified on any reasonable basis because it was said whatever duties were owed to the so-called blood Cherokees were also owed to the freedmen. And to further aggravate this, to deny the blood Cherokees or to exalt their interests to those of the freedmen just exacerbates the whole historical context of what happened here. Here you have a sect or an element, so-called blood Cherokees, who basically aligned themselves with the Confederacy, had their position in relation to the United States normalized, and then was given very paternalistic treatment by the United States. Whereas the persons held in bondage by the individuals who rebelled, who were less sophisticated and more capable of being exploited because of their lack of sophistication and education, were then told, but your land can basically be governed by the state courts of Oklahoma, and to the extent that you are not a minor, we're going to remove any restrictions at all or deprive you of any protection. So what we have here is under the Act of May 27 of 1908, at least as a minimum, because restrictions against alienation were retained as to freedmen minors, at a minimum, those minors should benefit from the same type of protection and paternalism that the so-called blood Cherokees received. And that has never happened. And that points out the dichotomy here and this disparity that we're asking this honorable court to, in referring to Cobell, accord the same protection and treatment to these Cherokee freedmen that has been accorded to the so-called Blood Indians, based upon the authority that was articulated very clearly over and over again by this court in Cabell concerning the nature of the relationship between these tribes and the federal government. I've asked to reserve 2 minutes, Your Honor, and I'd like to take advantage of that unless the court has further questions at this point. Thank you.
Good morning, Your Honors. May it please the court, Ben Richmond for the federal defendants. The court previously affirmed the dismissal of the nearly identical suit in 2017. It should affirm the district court's dismissal here for primarily 3 reasons. First, the federal defendants here have never held, nor have they ever been required to hold George Curls' allotments in trust. Second, the Act of 1908
That
here.
sounds like a merits argument. They've got an argument that you did still have trust obligations. You argue they did not, but the district court here dismissed for standing. A claim for an accounting is a long recognized form of injury, Article 3 injury. And so whether they're right or wrong on the merits is not something we decide at the standing stage.
So, Your Honor, it might help for me to explain a bit about how we got to this purported accounting duty argument here that came before the court.
And I'd also like you to add into that discussion, what do you perceive are your duties? Because it does say make reports, et cetera. I've looked up 10 Westlaw cases or so that even refer to the statute, and it doesn't ever give anything very explicit about that. So to the extent that you can add on kind of that history about why this act comes into being, because it is an act of protection, in regard to these lands.
Yeah, our position is that Act of 1908, it's purely discretionary authority for the secretary to investigate conduct of Oklahoma state probate courts. And so just getting into how the accounting duty argument, the purported accounting duty argument came before the court, the district court originally dismissed based on plaintiff's failure to demonstrate mismanagement. That was how plaintiffs originally pleaded standing in their complaint. That's at JA4, talking about losses in mismanagement established standing. The district court dismissed on that basis because plaintiffs had failed to demonstrate mismanagement. And then in the Rule 59 motion, plaintiffs then argued that there was a purported accounting duty and that the denial of an accounting was.
That's the relief requested in the complaint. It's all over the complaint that we want an accounting. So this isn't something that just appeared in Rule 59. This is what the complaint seeks.
The
It's an
complaint.
accounting, full stop. And
It
that's an
seeks.
Article 3 injury.
So whether the court frames this as a standing inquiry or an inquiry on the merits, the analysis and the results should be the
So they're
same.
very, very different things. They're very different questions. And the district court here dismissed on standing. Merits could be very complicated given the statutory scheme and the fact that federal courts were initially involved in handling the Curls estates, at least according to some of the documents, public record documents attached to the motion to dismiss. And the secretary had the capacity. We don't know if the secretary had appointed a representative in George Curls.
Plaintiffs had not pleaded that there's
They
any
don't know
representative.
if one was appointed. Do you know whether one was appointed?
No,
So
there's.
then we can't decide this merits question now. That seems like a pretty relevant fact question, because if a federal representative had been appointed, then the argument as to a duty, some sort of fiduciary protective duty, would be very different, but that's just an open fact question.
So, Your Honor, I think the denial of the Rule 59 motion, when the court addresses the purported accounting duty here, whether the court frames what the district court did in denying that Rule 59 motion as a merits inquiry or an inquiry into standing, again, the analysis is the same. The district court.
No, I mean, I'm sorry. I think it's really dangerous, and I'm surprised the government would be asking us to confuse standing analysis with merits analysis, because the government quite often tells us not to. So the question as to standing, she has the legal interest now, which she says you guys agree she does as the representative of the estate. She has a cognizable Article 3 injury, the request for an accounting as to the estate. And there's no doubt that it would be redressed by order of a court directing such an accounting. That's standing, full stop. And I don't hear you saying why it's not. I hear you saying why we don't think the law entitles her to an accounting, which isn't a merits question. But the district court ruled here on standing. Am I wrong? What about what I just said is incorrect?
Nothing that you said is incorrect, Your Honors. I think it's the unique nature of this case that the
It's unique about
injury.
this case that we should collapse standing and merits like we don't do in other cases.
I mean, I would.
We treat them differently.
Here, Your Honor, just I think because of the nature of the assertion of injury,
You
here-
think you have a very strong argument on the merits, I think, right? And lots of people think they have very strong arguments on the merits. But that's not the same as we don't then say the party doesn't have standing.
and
You
so
would agree with, that's the government, it's got to be the government's position.
so the government's position is certainly that standing and the merits are distinct inquiries, and if the court
And
feels
the
that we
fact
have
there's a really, I mean, there is, you are right, to be fair, there is an extremely narrow exception where a claim is asserted is so fanciful, frivolous, nonsensical, chimerical, that it doesn't even state a federal claim of law, but we're not in that area here. So they have standing, which is all the district court ruled. And then you have your arguments on the merits, but it seems to me that this is actually looking at the fact that there are actually documents in the record, public record documents in the record about where there is a federal court in the Indian Territory making decisions about the Curls children, including George by name.
a state court, Your Honor.
Yes.
Oklahoma State Court.
No, there are federal court ones. If you look at their attachments, Exhibit F to the response to the motion to dismiss, there are a number that are I just told you which court it was, in the United States Court for the Indian Territory. So there started in this case. I don't know how this shakes out on the merits, because this was briefed to us as a standing case and decided by the district court as a standing case. But it started with federal courts. And these are about Mr. Curl's father asking for appointments as to his children, listing George as one of them. And then the 1908 Act comes along, and then there's a couple in here that are probate court. But the question of what happens, two questions of what happens to the federal duty if they start dealing with an estate, does something continue, is a very different is a question that we don't have any information about in this case. And the separate question, which you said we just don't have any facts on yet at this stage, which is just standing, of whether or not a representative was appointed by the secretary, which would change the account, I won't say would, could change the accounting or the fiduciary duties, is an unknown fact. So we just,
So I would just say
I
the
think there's a
government.
lot to go back to the district court maybe on the merits.
The government adequately pleaded here failure to state a claim. There are multiple bases that if this court feels that it would like to.
You can't answer these, you can't answer the factual question of whether or not, there's actually three questions, I guess. You can't answer the factual question of whether or not a representative was ever appointed for Mr. Curl's children, including George Curl's.
So
That's a
so
fact.
there
You
are
can't answer
plaintiff.
that. I don't understand. I haven't seen any law here about what happens if originally the federal government is issuing orders and making decisions through its federal courts about this territory. And then there's supposed to be a transition to the probate court. What is the status of the government? That's very unique. What is the status of the government's, if any? Sounds like your argument would be none, and that could be right. But that's much more complicated once you see that federal courts were involved in these estates. And third, they have an argument, essentially, it sounds like sort of a equal treatment, equal protection.
So they
type
never
argument.
pled an equal protection claim here. And I would just say that this was a fee simple transfer to George Curls.
Well, because right
George
now, all
Curls-
they want is an accounting. It's once they get
But
their
there was no
accounting-
trust. There was no trust here to begin. So you can't even get to the question of an
That's a
accounting.
merits argument as to why they don't get, that's why they
And
don't
the
win on
merits argument in
merits.
standing here is one and the same because of
whether
how the
there's any-
district court denied the Rule 59 motion.
But whether
It's-
there's any trust may depend on whether a special representative was appointed. It may depend on.
There's
the-
no trust duty in the Act of 1908
There
whatsoever.
may not be, wait, well, hang on. There may be, there may be an argument, it would be different than what you're arguing now, if a representative had been appointed and hadn't fulfilled its duties, which we don't know that.
And
fact.
plaintiff has failed to plead those facts.
And
And
the
we
government-
briefed that he failed to state a claim. There were none of the predicates were ever.
That
pled.
is a 12B6 motion. We're here for a denial of standing.
And so if this court would like to look to other authority where courts have found that a failure to allege an enforceable fiduciary duty is relevant to a standing inquiry, you can look to Fletcher versus United States. That's a Federal Circuit case, 26 F 4th 1314. So there have courts, because of the unique nature of enforceable fiduciary obligations and whether that constitutes an injury in fact, courts have looked to the inquiry of whether there is an enforceable fiduciary duty or not
As a standing inquiry?
as a standing inquiry.
Okay, well, that doesn't mean I'm going to agree with the Federal Circuit on that.
Understood, Your Honor. I just want to also briefly speak to the Section 6 of the Act of 1908 in response to Judge Child's question. So again, to maintain a breach of trust claim, plaintiffs would have to establish that the federal government accepted enforceable fiduciary duties based on specific rights creating, duty imposing language in a treaty, statute, or regulation. Here, Section 6, which is relied on by the plaintiffs, provides at most discretionary authority for the Secretary to investigate Oklahoma probate court's treatment of minor lawtees. So the Secretary is empowered to appoint a federal representative as they may deem necessary to investigate conduct of state court-appointed guardians. And the federal representative then can form an opinion about that guardian's management. And only if a federal representative is appointed, and only if that federal representative makes findings about mismanagement, then there would be certain obligations for the federal representative to, for example, make reports to the Secretary. So that discretionary language, it's not rights creating, it's not duty imposing. And the Act of 1908, Section 6, does not mention an accounting whatsoever. And
are you saying that the accounting right only derives from that act, if at all?
it can only derive from specific rights creating, duty imposing obligations in statute, treaty, or regulation. And there's no statute, treaty, or regulation here that provides such an purported accounting duty. And even if
And
the
what is
court,
meant by the reports that are supposed to come from that act?
the reports would be if the federal representative made a finding about mismanagement. So that discretionary language, it does not create any rights. And again, there's no mention of a specific purported accounting duty in the actual act. And so I just want to come back to this basic point, though, Your Honors, beyond the language of the Act of 1908, that the Secretary here can't owe an accounting duty when nothing has ever been held in trust on behalf of George Curls. So Curls received his allotments as a minor by deed. This was a fee simple transfer directly from the Cherokee Nation to George Curls. And so the 1908 Act clarifies that jurisdiction is vested in the Oklahoma probate courts, where the state court would, for example, appoint a guardian to oversee minors' affairs. But the Act of 1908 itself, it does not create any trust. There is no trust corpus. There's no mention of a fiduciary, a beneficiary, a trustee. There's no mention of accounts. And that total absence of a trust corpus is why the Cobell case does not apply here. And Cobell,
Orders, I'm sorry, finish. Go ahead. Go ahead, finish.
in Cobell, that was a claim brought on behalf of plaintiffs when the government held individual Indian money accounts, trust accounts on their behalf. Here, the government does not hold anything on behalf of Curls. So again, that comparison to Cobell, it's just inapplicable here.
So in the record, we have these federal court orders pertaining to these estates and appointing guardians. And it's just not, this is not the probate, and this is actually.
But the appointment.
Excuse me, this is pre-1908 Act, but it involves the very estate at issue here, or the George Curls land, which becomes the estate at issue here. And so if the federal government was entering orders as to that land, is there anything that tells us one way or the other whether a trust could have attached even before the 1908 Act.
And so a trust duty, an enforceable fiduciary duty would only attach based on specific rights creating, duty imposing language. And, you know, a single, I'm not familiar with that specific order about the appointment of a guardian here, Your Honor. But
It's all
that-
attached, these were all the documents attached to their motion to dismiss, and they're public record documents. Can a court order impose a trust?
not unless it's a rights creating, duty imposing, excuse me, no, it could not, because it's not from a statute. It's not from a treaty. It's not from a regulation. It's the sovereign authority of the executive. And
Before 1908, if you're in a non-state, in a federal territory.
again, I'm not aware of any legal precedent that allows a court order to create a trust duty, even if we're in a federal territory.
We just don't know sort of in that time. That was a.
And again, I think if there were such a rule, it would controvert Supreme Court precedent. I mean, Arizona versus Navajo Nation. The court is very clear. You can only create an enforceable trust duty based on your rights creating, duty imposing language in a treaty, a statute, or regulation. I'll also just add that the court has an alternative basis here to affirm, and that's based on the failure to plead mismanagement associated with the allotments here. There were no pleadings in the complaint about specific leases executed on behalf of Curls. There were no allegations about specific mismanagement by a guardian or curator. And again, we would argue that plaintiff hasn't pleaded traceability either, because they haven't shown how George Curls would receive more or a different amount of royalties had the federal defendants fulfilled their purported statutory duties. So unless there are any questions from the panel, Your Honor,
Thank you.
for these reasons, should affirm the judgment of the district court.
Oh, all right. Why don't you take 2 minutes?
Thank you, Your Honor. Your Honor, I would just say, in response to a couple of points raised by opposing counsel in relation to the trust corpus, the leases and the treatment of the leases in this case are something that we have no information because we've never gotten beyond the threshold point where we could begin to do some discovery. The other thing is the act of May 27th, 1908, if you really look at the impact and its intent, the thing that act accomplished was it opened up land that had been allotted to freedmen for settlement in Oklahoma. This act occurred at approximately the same time as Oklahoma statehood. And basically what occurred was that by removing these restrictions on alienation, it gave settlers in the Oklahoma territory the opportunity to basically exploit the freedmen, whereas the protections were retained for the land that had been allotted to the native Cherokees and to freedmen miners. The other point, Judge, is that this court stated in Corbell versus Norton that the Trust Fund Management Reform Act required the secretary to prepare periodic statements and account for the performance of balances to account holders. This only goes to the point I raised earlier about the fact that Cherokee freedmen were never given individual Indian money in accounts because they were basically, for lack of a better term, thrown to the wolves, whereas their Cherokee natives were the same land, was the basis for their individual Indian money accounts. And in 1994, Congress passed legislation that acknowledged fiduciary duties of the secretary owed to beneficiaries of individual Indian money accounts. So at a minimum, the treatment accorded to the Cherokee freedmen here perpetuated past discrimination. There was no reason for restrictions on alienation against their allotments to even be removed in 1908, and they were removed in order to make it easier for them to be exploited. Thank you very much, Your Honor.
Okay. Okay. Let's see here. No, I know.